Hello and welcome everyone for the preparation of CLAT examination. Uh, we have been discussing about the different parts which are going to be helpful in your preparation for the CLAT examination. Specifically, we are focused towards the legal reasoning portion of your syllabus, which we have been practicing the different portions of the legislations which are going to be asked in your CLAT examination. We have so far completed the Indian Contract Act. We have also completed the criminal laws, and we have completed the constitution along with the law of torts. In our previous video, we started with the family law. We have so far completed with the sources of the Hindu laws, which we discussed about what were the sources. We discussed about Shrutis, we discussed about Smritis, and then we discussed about the commentaries and the digests, which we discussed about the Mitakshara school, the Dayabhaga school, and then the different schools which were formulated after the commentaries and the digest, which gave rise to the Mithila school, the Banaras school, the Dravid school, the Bengal school, and so on and so forth. We discussed about the importance of legislations and about the different customs which are prevalent, which helps us in formulating the rules which are going to help us in running the families as such. Then in the ancient laws, we have studied about all these type of sources, but then there were more modern sources also, which we studied about the precedents. We studied about the Hindu Marriage Act. We studied about the Hindu Adoption and Succession Act, and we also studied about the Hindu Marriage Act, Hindu Divorce Act, Hindu Special Marriage Act, and Hindu Maintenance and Adoption Act. So all these acts are considered to be the modern sources of family law in regards to Hindus. But we are not only confined towards the Hindus, but we'll also have to look forward and see what are the other religions or other personal laws are depicting and suggesting in regards to the maintenance, in regards to their marriages, in regards to the divorce, in regards to the maintenance, in regards to the families in total. So in our this particular lecture, we will be focusing towards the Muslim sources of family law. That what exactly are the sources. Hindus we have studied in our previous lecture, and it is a detailed video. If you want to understand that, what you can just refer to that video, and you will be able to understand that what actually are the sources. So we have just marked the timeline, and we have tried to explain each and everything in regards to the sources of family law in regards to Hindus. Now let's start with the Muslims. And in that particularly, I suppose the screen is visible to each and every one of you. When we talk about Muslims, as you know that Muslims have a different sect of beliefs. They have a different belief in regards to the God. They have a different mindset as to how the marriage should be. And when we compare Hindus with the Muslims, and we talk about marriages as such, so in Hindus, marriage is considered to be a sacrament, but in Muslims, marriage is much more considered as a contract. So there is a difference in the approach of both the religions when we talk about the Muslims, when we talk about the Hindus. So basically, the point here is that the sources of these two religions are also different. In Hindus, we talked about the Shrutis, Smritis, but when we talk about Muslims are only confined towards one important thing, and that is Quran. So everything whatsoever has been mentioned in the Quran, Muslims will obviously be confined towards those principles and the regulations and the rules, and based on those rules and regulations, the Muslims have provided the source and use that source, and the only source which we say is a valid source in regards to the sources of family laws in regards to Muslim is actually Quran. So let's try to understand that what are the things that have the timeline which has actually inculcated the whole stem of the laws which are prevalent in the Muslim sector of the society and how they are governing the marriages, divorce, and succession as well as maintenance. So first, in the same manner we have studied about the sources of the family law in Hindus. In this lecture, we will be we will be focusing our mind towards the Muslims, and we'll try to understand that what are the different schools of the Muslims and Muslim laws, and what exactly is Shias, what exactly is Sunnis, and how all the origin of these laws took place. So for that, I like to share with you the whole story, the whole segment as to how the things happened, how the Quran came into play, who is Prophet Muhammad, and everything. I know I expect that majority of you might have this particular feeling, how is it related to CLAT as such? How is it related to CLAT as such? So my point here is that it might not be that much relevant, and it might not be helpful for you when you talk about CLAT examination as such. But the underlying principles which you'll understand when you'll have the sources in your mind, it will help you in analysis that, okay, if the sources has been in a different way and different direction, then obviously I'll have to think in that particular direction only. For instance, if you're talking about Muslims, you have this ideology in mind that yes, Muslims have contract in regards to the marriages. So now you are clear that all the principles that has to be applicable in regards to the contract will be applicable in the marriages of Muslims also. But when we talk about Hindus, that is perhaps not true, because in Hindus it is still considered as a sacrament. So the rules that is going to be governed by the for the Hindus in regards to the marriage, divorce, succession, and maintenance obviously has now been codified, and that is why we will directly refer to those legislation, and we can use those laws, and we can see through it whether the marriage has been solemnized on the basis of those rules and regulations, or there is some conflict, or there is some loopholes which has been left, which makes the marriage voidable or a void marriage. But in regards to Quran, in regards to Muslim, there is no such codified legislation which can be used in order to explain that what exactly is the law, what exactly has to be done. So in this regard, the Muslim sources of the family law, in regards to the Muslims becomes very important, because you need to understand what exactly are the principles that has been followed, and what exactly the Quran says in regards to the marriages, in regards to the divorce, in regards to succession and maintenance. So Muslim law, as you already know, is a divine law. When we say divine law, it means a law. Muslim law is a divine law. And when we say divine law, what do you understand by divine law? It means that a law that has been created by God itself. So if there is any law that has been created by God itself, that is considered to be a divine law. And perhaps that is the reason that the Quran, which is considered to be the divine law, is being favored in regards to any of the conflicts, or any of the sources, or any of the rules that can be utilized, that will be there in regards to marriage, divorce, succession, and maintenance in regards to the Muslims. So it is the Muslims. I have just explained it to you that the Muslims will obviously focus over the Quran in order to understand that what exactly are the rules and regulations that needs to be followed by the Muslims in regards to all these things. And so Quran becomes an important point, because it is a divine law. It is a divine law which suggests all the laws that has been created by the God itself. So whenever there is anything which has been created by the God itself, that has to be considered as a very important point. But the question here arises that how come were we able to figure out that, okay, these are the laws that has been provided by the God, and how the Quran came into existence? That is something that we need to understand. So I'll be just providing you with the timeline so that you get a better idea that how the Quran came into being, and what exactly is the role of Prophet Muhammad, and how the existence of the two sect of the society, two communities, one being the Shia and one being the Sunni, came into being. Okay, so let's start with that. let's try to understand that what exactly the timeline as to how the things went forward and how we have created the different legislations or the laws in regards to the Muslim. So as we know that if we are talking about Quran, and when we talk about Quran, it is the divine law. It suggests that it is a divine law for Muslims. So when how the Quran took place, that first you need to know that Quran is considered as the only revelation or revealed book. So book is a sort of a codified form. So although they have no separate legislation like the way Hindus have. For example, you have a Hindu Marriage Act, which is talking about the marriages. Hindu Succession Adoption and Succession Act, which is talking about succession, and then Hindu Adoption and Maintenance Act, which is talking about the maintenance. But rather, when we talk about Muslim, there is only one codified book. If we say, then that is the Quran. So Muhammad was the last prophet, as you have studied, that Muhammad was the last prophet. Only Quran is considered to be the codified book which talks about the rules and regulations that has been provided by Allah. Okay. And the one more thing that there has been a confusion in regards to the Muslim sector of the society, that is that in Muslims, the society is not divided on the basis of caste, not divided on the basis of caste, because there is a misconception in between majority of the students that just like in Hindus we have the different caste, the different communities, but in Muslims we are not actually saying that it is divided on the basis of caste, but rather it is divided on the basis of ideology. That what exactly is the source of the codes or the source of the rules and regulation. So the ideology is different in regards to the two sects of the society that is prevalent in Muslims. One sect is known as Shia, and other one being named as Sunni. So I'll just explain it to you that how all the things came into being and how exactly the ideology, and both of them differs not only on the basis of caste but on the basis of ideology. So ideology. So this was one question that was asked in your CLAT examination, that the division on the basis of what the Shia differs from Sunni is. Then they have given the four options, one being the caste, one being the principles, third one being the ideology, and fourth one being all of the above. The students have marked all of the above, but the correct answer would be the ideology. What is the idea, the rules behind, the principles behind, the morals behind taking the step forward in regards to marriage, divorce, succession, maintenance, and everything. The ideology is different. The perception of the society is different in regards to the Shia, in regards to the Sunni, and that is why it is important to understand that how all these things came into being. Okay, so we'll try to explain it to you via way of pictorial representation so that it becomes easier for you to understand. Okay. This was Quran. And let's talk about Prophet Muhammad. Prophet Muhammad. Prophet Muhammad. So when we talk about Prophet Muhammad, he was born in the year 5071 AD, and he was raised by his grandfather. His grandfather he was raised by his grandfather, whose name was Abdul Muttayyab. And the reason for raising Prophet Muhammad by his grandfather was that both the mothers and father of Muhammad died, and then the reason, and because it was there was no mother and father, he was raised by his grandfather whose name was Abdul Muttalib. And after he reached the age of 40, Prophet Muhammad, okay, so this is prophet, let's just let's name it like P so that it is better understood. So this is the prophet, and prophet was raised by his grandfather. So mother and father both have died. And in our previous lecture series, I just explained it to you that what is the significance of the brackets. So it signifies that both the people have died. And so prophet was raised by his grandfather whose name was Abdul Muttalib. And prophet had one cousin with the name of Ali. Okay. Prophet had one cousin with the name of Ali, and then Prophet had married one wife with the name of Khadija, and then there was another wife. So Prophet actually married 3 wives. So if you see that when you talk about Muslims, so you see that in Muslims personal laws, it is not polygamy. There is one word which is known as polygamy. So when you talk about Muslims, polygamy is allowed. Polygamy is allowed means that one husband can have multiple wives up to a limit of 4. So maximum 4 wives one husband can have. But when you talk about Hindus, you will not find that mention that a Hindu can also have 4 wives, because in Hindus polygamy is not allowed. So you see, if you can analyze, if you can see that there is a difference in approach altogether from this very starting, from the very beginning of the laws. From the sources itself, we are able to understand that when you talk about Hindus, only monogamy is allowed. You cannot marry another wife. If you marry the another marriage will be considered as null and void. That marriage is not valid at all unless both the spouse, the wife of the husband has died, or because of a divorce or anything. Then only he is allowed to marry another person. In the same way, it goes for the wife also. Until unless the husband is married, she cannot marry another person. So, but when you talk about the Muslim allows polygamy in regards to husband itself. It is not like that the woman, it can be given, woman can also marry 4 husbands. But on the contrary, husband has been given this right that they can have a valid marriage of up to 4 wives. And that is what polygamy is in regards to Muslims. So, in the same way, Prophet has married 3 wives. The first wife name was Khadija. And then there was another wife. I don't want for you to just get confused, so I'm just focusing over the names which are actually relevant. And then another wife. Then the third wife was Aisha. And Aisha was the daughter of Abu Bakr. I'll just write down the names for you so that you may be able to understand how the chronology actually came into being. Now, Prophet had a daughter from the wives, and then the daughter's name was Fatima. The name of the daughter was Fatima, who actually after a certain period of time got married to Ali, who is the cousin of Prophet. So Prophet's daughter actually married to the cousin of the Prophet, that is Ali and Fatima. So they were married. So till this point, you are able to understand that family tree of Prophet Muhammad, that Prophet Muhammad had a mother and father who died earlier. He was raised by his grandfather, Abdul Muttalib. He had 3 wives, Khadija, another wife, and then the third wife whose name was Aisha, who was a daughter of Abu Bakr. Why the name of Abu Bakr is relevant here? Because in the later stage you'll find that there was a revolt that was done by Ali and Abu Bakr on one side, and then there were followers of Prophet and the wives of Prophet on the other side, which got into the creation of the two sects of the society, one being the Sunni and one being the Shia. So what happened that at the age of 40, when Prophet was meditating, he got a revelation, and that revelation, let me just clear it out for you for your better understanding. Yes, so at the age of 40, what happened was that Prophet was meditating in a cave called Hira. So there was a cave with the name of Hira. In that cave, Prophet was meditating, and when he was meditating, he received a first revelation. First revelation means the first revelation, that is the first message of the God, that is Allah, that he received the first revelation of God, Allah, and that revelation was known as Wahi. This is the first revelation, and it was communicated to Prophet. This first revelation that is known as Wahi, when he was meditating in the cave of Hira. This Wahi communication was given to Prophet by the messenger of the God, whose name is Gabriel. So this is how the angel, who's considered to the passer of the revelation, that has been the message of God Almighty to Prophet, was received at the age of 40 to the Prophet when he was meditating at the cave. Okay, and that particular belief that he has received that particular message from the God, then from this point of time there was a conflict that came into being. The first conflict that came into being when this particular thing happened first was that there were some followers who believed that that Prophet Muhammad has received that particular message, that particular revelation, and there were some who believe that there is nothing that the God will only send the revelation to Prophet, but rather whomsoever will read the Quran, the message will obviously be passed to them also. So then this particular confusion or this particular conflict gave rise to majority of the things. But what happened after the revelation was received, that there became a two sect of the societies. One which was following Prophet Muhammad, that he has received the revelation of the God. And then there was another sect of the society which was governed by Ali and Abu Bakr, who had this belief that the information, the validity of the message that has been provided will obviously be received if you will read the Holy Quran, and the leader should be chosen according to Ali and Abu Bakr, that the leader should be chosen by voting. And the followers of Prophet Muhammad said that since Prophet Muhammad has got the message of God Almighty, then he should be, or rather Prophet Muhammad should be chosen the leader. So the followers who practiced this point, they were the wife of Prophet, that is Khadija. Then there was one scholar of Prophet whose name was Waraka. He was the blind scholar. He was blind and he accepted that Prophet has got the revelation of the God and his information is not wrong. He is correct. And the same way, Then there were another followers who were Abu Bakr. Initially, he was following it. Then there were Umar, and then Usman. So these were the followers of Prophet who believed that yes, Prophet has received the revelation. And then there was another sect of the society where which Ali was the uh, prominent person who was considered that no, it should not be in such a manner that he should be given the leadership, but rather there should be voting, and then accordingly the people should choose that who should be the leader of the society. So in this manner, we got two sectors of the society, one being Sunni and the other being Shia. So Shia are those people who believes in Prophet Muhammad and he should be choosing the leader, and they wanted voting. So after this particular revelation took place, there was a lot of humiliation that went through, and Prophet was humiliated, and he was opposed and persecuted and dragged from the temple of Mecca. He was dragged from the temple of Mecca, and because of that, he fled. He fled and went to Medina. In 622 AD, he went to Medina in order to get stronghold of the people, and he formed a political party, which he there in Medina he formed a political party which was called Ummah. And then through this particular point onwards, there was a different group that altogether followed. But after the death of Prophet Muhammad, this particular difference between the Shia and Sunni become much more relevant, and because of that, the schools it led to the creation of two different type of schools. One being the Shia school, and another being the Sunni schools of thought. So we are not going to deal in depth in regards to what exactly the schools of the different these two societies says, but you need to know the name of these schools, because there are questions that will be asked to you in your CLAT examination. So it becomes important to remember that what exactly are the schools. So these are the Shias and these are the Sunnis. So the first school that has been named for Shias is known as Ithana Sharia. This is the first school of thought. Then you have another school of thought that is known as Ismailia, and the third one being Jihadis. So in the same way, when we were studying the Hindu laws, we studied that there were Shrutis and Smritis. And then from the Shrutis and Smritis, we got the two commentaries and digests, which were focusing and in details explaining what exactly is Smritis. In the same way, because of the diverse region, there were different schools which were altogether have something in similarity, but there was different approach. So according to the approach, according to the ideology, it gave rise to the different schools. And in regards to Shias, there were three schools, one being Ithana Sharia, second being Ismailia, and third being Jihadis. So for your CLAT examination point of view, you are not supposed to delve deep inside what exactly is Ithana Sharia saying, what exactly is Ismailia saying, what exactly is Jihadis saying. For you people as of now, the only understanding that you need to know is that there were schools that have difference in opinion, and all the three schools, Ithana Sharia, Ismailia, and Jihadis, was the schools who believed in the policies and the principles of Shia school, most specifically Prophet Muhammad. And then you have Sunni schools. They were divided into four schools. The first one being Hanafi school, second one being Shafi'i school, third one being Maliki school, and the fourth one being Hanbali school. schools. So these four, the names are very important. You need not go and delve deep into the exact what exactly has been mentioned in that particular schools, but you need to understand that there is a difference in the ideology of all these schools. These three schools, Thanasari, Ismailia, and Jihadis, follows the same ideology, and in the same way, Hanafi, Shafi'i, Maliki, and Hanbali schools of the Sunni sect follows the different ideology. So the names are important. I would request you to just understand the names. Don't give deep delve inside the philosophies. So from this point of time onwards, these were considered to be the major schools who provided, okay, that these are the ideologies and these should be the principles which needs to be followed. After the creation of all these schools, which helped us in understanding that what exactly Quran says about the marriages, what exactly the divorce, how the divorce needs to take place, how the succession needs to take place, and all these schools helped us in creation of the different sources of laws, which provided us with the two set of things, first being the primary sources of law and second being the secondary sources of law. In Hindus, when we were studying, we studied about the ancient sources and the modern sources, but since from the very beginning, Quran is considered to be the only source in regards to Muslims. So there were interpretations that were given by different people from the different political societies, from the political groups, which have different interpretation. And by the understanding of the different interpretation that has been given by the different sect of the classes of the schools, in regards to Shia school, in regards to Sunni schools, we were able to figure out that what exactly has to be the sources of law. So for Muslims, we have again further subdivided the schools on the basis of, so basically under the Muslims, if we talk about Muslims, then there are 8 major sources of law. The first 4 are considered to be the primary source, and the remaining 4 are considered to be the secondary source. So we will be dealing in the primary source also and the secondary source also, in order to understand that what exactly is the primary source and what exactly is the secondary source, or if I will say the informal source. So the first primary source. So we are talking here about the primary source of Muslim law. So the first and the primary source, I would just take maybe 30 seconds or 10 seconds pause, and I would like you to brainstorm and figure out that what should be the main source of the primary source of Muslim law. Any idea, guys? Any guesses? Perhaps you might have been able to figure out by yourself. The first and the foremost and the most important source in regards to the Muslims is obviously the Quran. The Quran provides all the important principles, and which helps us in understanding that what exactly has been there. Some important facts about Quran is that it is derived from Latin. It is derived from Arabic word. It has been derived. Quran has been derived from an Arabic word which is Qora. Okay, and which means to read. So to read the principles, it has been the Quran has been mentioned, and it is collected and arranged. It was collected and arranged by Abu Bakr. Abu Bakr, the first Caliph. He is considered as the first Caliph. With Abu Bakr's daughter, Aisha, a prophet got married, and this Quran was revised by Usman. He is considered as the third Caliph. Okay, so Quran is considered, and of so this is Quran. Prophet has received around 23 revelations during his lifetime, And all these revelations has been interpreted and arranged by Abu Bakr and Usman in the Quran. So Quran becomes a primary source of Muslims when you talk about the sources of laws in regards to Muslims. So the second one, first is Quran, the second one is the Sunnah, which is known as the path. Okay, so the first is Sunnah, and the first is Quran, the second is Sunnah, which means the path. It is a second source of Muslim law, and whatever the Prophet did or allowed is called as. So whatever the Prophet used to did, whatever he did or he allowed doing was considered as hadith. So these terminologies, these words are important because you might be asked in a CLAT examination that whatever the Prophet did or allowed has been given a nomenclature. What exactly is that nomenclature? So for your understanding, you should know that what exactly is hadith. And whatever the Prophet did, sorry, not did, but actually rather said in words is considered to be Sunnat ul Qawl. Is considered as Sunnat ul Qawl. Okay. And whatever he did, it is known as Sunnat ul Fail. And whatever he allowed to be done is known as Sunnat ul This is QRIR. So these are the things that what Prophet has actually done during his lifetime. So the followers have accepted that is the source of law, and that is why it is known as Sunnat ul Qawl, Sunnat ul Fail, and Sunnat ul Kri. So these are also considered to be the second source of law, that whatever the Prophet did during his lifetime, that is also considered as a source of Muslim law. So this is also a source of Muslim law, the second source. The third source is Ijma. The third source is Ijma, which is the consensus of the most learned members of the community. The most learned person of the community is considered to be Ijma, and the fourth one being Qiyas, which is a method of analogy and interpretation derived from Sunnat and Ijma. So Sunnat is the second source of law, and Ijma is the third source of law. So whatever the methods and analogies and interpretation has been derived is compiled and formed another sect which is known as Qiyas. Okay, so these are the four primary sources of Muslim law. But what about the secondary sources? We do have the secondary sources also, and these perhaps the secondary sources and the sources under the Hindu laws are perhaps the same, and that consists of obviously legislation. First is legislation. The second one is customs and usage having the force of law. Then the third one being the judicial decisions. Judicial decisions. The fourth one being justice, equity, and good conscience. So these are the four secondary sources of Muslim law, and the primary sources we have already discussed. So with that, we are able to understand that there are different sources of Hindus law also and the Muslim law also. Both the Hindu laws and the Muslim laws are different in their approach, and because of the difference in their approach, we cannot unifiedly prepare a single form of law which can govern the Hindus also, the Muslims also, and perhaps the other religions also. So although we have under Article 44, under Article 44 of the Constitution, that the talks of a uniform civil code, but perhaps it becomes very difficult and almost impractical and impossible to have one particular sect of rules in the society which can govern both the Hindus and the Muslims, because since we have now understood that there is a difference in approach altogether when you talk about the sources of laws in regards to Hindus and Muslims. So because they are following a different sect of laws, in when you talk about Muslims, they are following basically the Quran, then the interpretation of Quran by the different sect of the people. And when you talk about Hindus, they are much more inclined towards the Shrutis, the Smritis, and then after the Shrutis and Smritis, what exactly has been mentioned by the different schools of thoughts. And basically after that, in order to remove those conflicts and chaos, there was a codification of laws that took place, and perhaps that is why it became easier for the Hindus to get the reference, because now they have the codified laws. They have Hindu law, they have Hindu Marriage Act, they have Hindu Adoption and Maintenance Act. But when you talk about Muslims, the law is still not codified. So they resort to the Quran in order to understand that what exactly the law says. And that is why it becomes a entirely different topic and discussions altogether, that the applicability of uniform civil code under which has been mentioned in the Article 44 of the Constitutions become almost impossible. But still the parliamentarians are working over it to figure out that if there could there can be any way by which we can make the laws which can be universally applicable throughout the territory of India. And let's see if they can bring out some legislations in such a manner that which does not conflict by the personal laws. Then we will for sure see through it in the future that we are studying one simple laws instead of the different laws that is supposed to be studied. So I suppose you are able to understand what exactly is the sources of Muslim law. So we have completed with the sources. We have completed with the sources here. So sources of family law in regards to Hindus and the Muslims has been discussed. And there is one thing that I would just explain it to you, and that is regards to customs, because customs has found relevance as the source of family law, both in Hindus and Muslims. So it becomes an important topic for you to understand that what exactly custom means, and why is it necessary to make sure that the customs have a valid ground. Anything which has happened in the past cannot be considered as custom. There are certain requisites that one needs to follow and one needs to keep in mind if at all they want that a certain custom should be considered as a source of law. So let's study and let's try to understand that how a custom can be considered as a source of law. Custom as a source of law. Is it possible? Yes. So in order to have custom as a source of law, there are perhaps 5 requisites, 5 essential which a custom should have in order to make sure that the custom can become a source or it can become a law. The first and the foremost important requisite is reasonableness. Reasonableness. It is the custom should be reasonable. It should not be something which is entirely impossible to do, and it is something which is going to affect the society at large. It should be reasonable. The first requisite it should be reasonable. The second requisite is it should be uniform. A custom is something which is consistent. It is not like that for a certain period of time you followed it, then after a certain period of time you fail to follow that particular custom and then again you start following it. Then it cannot be considered as a custom. For custom to be prevalent and to be considered as a source of law, it is perhaps very important that the custom should have consistency. It should have reasonableness. So when it is reasonable, some custom, for example, a custom where which it is harming the society, harming the person, then that custom is not actually reasonable to do. And that is why it should not be considered as a custom. If the custom is not uniform, if not uniform for a certain period of time you followed it and then you rejected it, then you again started following it. So there is no uniformity as such. So that also cannot be considered as custom. But if these two things are there along with the laws, it should be ancient. Ancient means it should be followed from a very long period of time. Long period of time. Now, what do you understand by long period of time here? Because long period of time can be 10 years also. It can be 20 years also. It can be 5 years also. So how we are going to calculate that this is ancient? So it has been mentioned that anything beyond a period of time from which the generation has come into existence, that will be considered as an ancient time, from long period of time. And the date, it is something which is mentioned as beyond 100 years. If something is there beyond 100 years, then it can be considered as ancient. The fourth one is certainty. That it should be certain that this particular custom has to be followed on what grounds, when this custom has to be followed. It is not like that the custom should be followed everywhere, anywhere. There should be a reason and there should be a certainty that this particular point of time, for example, if you talk about customs in regards to Hindu marriage. So there is a custom that there will be saptapadi. We have discussed this earlier also, that against the holy fire, both the husband and the wife will take rounds and 7 rounds needs to take place. So this is a custom which has been followed from time immemorial, and that has reasonableness. It was reasonable because it is considered that it's a holy fire, and once you take the holy fire, you are abiding, you are committing to the promises and the vows that you're going to take place. It is uniform. It is being followed from it is uniform that it has to be followed whenever the marriage needs to take place. It is ancient. It has been followed from a very long period of time. There is a certainty that this has to be followed whenever there a marriage is going to take place. Then you have obligatory, that there should be an obligation to follow that custom whenever the marriage needs to take place. We have to follow the saptapadi. So there should be an obligation for the custom to be there. And the sixth one is done, Shahid. Yes. Now, the sixth one is that should not be immoral. It should not be immoral. Should not be immoral. Earlier days, there was a practice of sati prata. You must have heard sati prata. If you would have watched the movie Mangal Pandey, then you would have known that there was a sati prata in which if the husband has died, the woman has to sit in the holy fire along with the dead body of the husband in order to give the sacrifice that yes, I am since my husband has died, I have but no other reason to live in this world, and I want to die along with my husband. So this particular principle or particular custom was considered as immoral, and it was abolished during the British's time, and that is why that particular custom was not considered to be a valid custom. Then the seventh one being should not be immoral opposed to public policy. Should not be So this is done, should not be, and it should be continuous. This is 6.1 is done. It should be continuous without interruption. So perhaps this uniformity and the 7th one is the same. So you can just ignore the 7th one. It is perhaps only the 6 important requisites which are there. First one is the reasonableness. Second one is the uniformity. Second being ancient. Then you have certainty. Then you have obligations. So all these 6 points, if are present in any sort of a custom, then that custom has the legality or has that power to be considered as a law, and that custom will be considered as a valid custom. So why we have studied custom? Because often you will be asked, and there is one more word, and that is antiquity. So these are the things that you need to remember when you talk about the source of law. Of custom has to be a source of law. It has to comply by all these essentials. If these essentials are present, then a custom can be considered as a valid custom. And this is considered to be a source of law, not only for Hindus, but for Muslims also. So that is why we need to understand that custom find relevance not as a source of law, not in the Hindu family law, but also in the Muslim family law. From tomorrow onwards, so we have completed with the sources of family law. We have completed with the sources of family law. We have completed the sources of family law. We have understood what is the sources of family law in the Hindus. We have studied what are the sources of family law in the Muslims. And now, and that is more than sufficient in regards to your CLAT examination. Now we will be shifting our focus towards the marriages. From tomorrow onwards, we will be studying about marriages under Hindu law, how it is being governed, which code we will refer. The code that we will be referring in regards to the marriages under the Hindu law, it is the Hindu Marriage Act of 1955. We will be taking reference to that particular legislation, and I'll try to explain it to you in a very short, crisp and clear manner that how the marriage under the Hindus take place. Once we are completed by how the marriages under the Hindus take place, we will be resorting towards the marriages under the Muslims. Then we will be coming back towards the divorce, then the succession and the maintenance. And this is how we are going to plan the whole syllabus of family law in regards to the legal reasoning portion of your CLAT examination. One thing that you need to understand in this particular session when we are conducting in regards to the legal reasoning and in regards to family law, that the questions that will be put up in front of you will obviously be coming from essentially from these two areas, which is the marriages, the succession and the divorce. So these are the most important portion of your family law syllabus, and you need to understand that what type of things needs to be studied. When you talk about marriages as such, the things to study under marriage is, the first is essentials of marriage. Then competency of marriage, who all are competent to marry. Third is who will be governed by the laws of marriage codified, that is the Hindu Marriage Act 1955. So upon whom all these laws that has been codified under the Hindu Marriage Act will be governed. So when we study section 5 of the Hindu Marriage Act, you will find the essentials. And in the very beginning, the Hindu Marriage Act will explain who exactly is a Hindu. Exactly is a Hindu. And whomsoever is Hindu has to abide by the laws that has been created and codified in regards to the marriages, divorce, succession, and maintenance. And if by birth or by domicile or by residence, if you've been considered as a Hindu, then it is obligated towards you to follow these laws. So that is why it becomes important for everyone whomsoever is a Hindu to understand that what exactly the code of this particular legislation, that is the Hindu Marriage Act 1955, suggests about the essentials of marriage, competency of marriage, who will be governed by the laws of the marriage, then what type of marriages are types of marriage. Types of marriage, that is, there are three types of marriage in Hindu law, that one being the valid, another being the void marriage, and third being voidable marriage. So these are the things that we're going to study when we'll start with the marriage portion of your family laws. And once you will be acquainted by these type of these essentials and these competencies and what exactly the law is suggesting about the marriages under the Hindu law, you will be able to at least get a clear idea that how the marriage needs to take place and what are the conditions precedent which needs to be fulfilled if a valid marriage has to be there. And if those conditions are not fulfilled, whether the marriage will be considered as a void marriage, whether it will be considered a voidable marriage, these are discussions that we're going to take that are going to be taking place once we start our lecture series over the marriages portion of the family law. After the completion of the marriage in regards to the Hindus, we will be shifting our focus towards the Muslims, how the marriages under the Muslim take place, what exactly is Sahih, what is Fasid, and what is Batil, the three types of marriages that can be present. There is one more thing which is known as irregular forms of marriage. To what extent a husband can marry another wife, and what are the conditions in regards to that also. These are all the things that we're going to study in our upcoming classes. So that is the whole crux, the overview of what we are going to study in our next class. In the today's lecture, we have completed by the sources of family law. We have completed both the Hindus as well as the Muslims. And from tomorrow onwards, we will be focusing strictly towards the marriages. And this is how we are going to move forward with. We are going to first understand who exactly is a Hindu. And we will be taking a reference of what? We will be taking reference of one legislation, one code that has been created by the parliament, and that is Hindu Marriage Act of 1955. So this is the code which has now been formulated by the parliament. We remember that we have studied the sources of Hindu laws. We have studied that there are two types of sources, one being the ancient source and another being the modern source. So the ancient source has been codified in form of modern sources. So one of the modern source that has been created by the parliament is the Hindu Marriage Act. So the Hindu Marriage Act, as the name suggests, provides us with all the rules, all the legislations that needs to be there whenever you are talking about marriage between Hindus. Okay, so these are the things that we are going to study in our upcoming classes. I would again request you to kindly continue with your preparation for the CLAT examination. Follow the three principles, the three P's, which I have always explained it to you. First being the principles, the applicable principles. The second being persistence. And the third one being practice. So practice, persistency, and remembering of the principles will help you out in clearing your CLAT examinations. All you need to do is start practicing as much as you can so that you are able to analyze how the questions would be and how the see all the concepts whichsoever I have taught you so far are going to be helpful for you in analyzing and understanding that what exactly has to be the answer of this particular problem. And once you are able to understand the principles, then you have to apply these principles while you are practicing the mock papers, the PYQs, which will assist you in analyzing that how the questions will be. And as I've just explained it to you in our previous classes also, that CLAT examination is not about learning and grasping what exactly is Hindu Marriage Act, what exactly is Quran, what exactly is Sahih Batil Fazil. No. Actually, the student get confused that, sir, I will have to remember each and everything. How will we be able to remember it? It is not about the remembrance. You are not going to be asked that under section 123, what exactly is written. No, you won't be asked that because you are not supposed to read it. But the underlying principles means if a custom has to be valid in source, then what are the essentials? These type of things will be asked to you. Then they will be giving you 4 options, 1, 2, 3, 4. And then there will be reasonableness, antiquity, ancient, and unique. And then you will have to ask that, okay, this whichever option is odd, you have to remove that out. So this is how the concept is important for you to analyze the questions that will be asked in front of you in your CLAT examination. And once you start practicing it, you will be able to understand, okay, this concept has to be applied in such a manner that I am able to figure out what exactly is the answer. So concept is important, grasping the concept is important, but memorizing it is not important for you. So once the concept is clear to you, it is recommended that you start practicing the PYQs and the mock test so that you get a clear idea that what exactly needs to be studied when you're talking about the CLAT examination. With this, guys, I would like to thank you all for being present in this session. We will continue our session from tomorrow onwards, and in that session we will be talking about the marriages of under the Hindu law, and then we'll move forward with the Muslim law marriages. Till then, thank you so much, guys, for being present here. I wish you the very best of luck. Tata, bye bye, take care.